Nearly. Kalyani is
call everyone. Just tell them that I'll introduce all of you. Speak to Tamara. Okay, you guys come now.
I request all audience members to take their seats. We shall be starting. Good morning, one and all. It's my honor and privilege to welcome all of you to the final session and the valedictory of the Bangalore ADR week. The final session is the great debate. I shall now introduce the speakers who shall be joining us on the dais. I request the speakers and the adjudicators to join us on stage as I call out your names. Mr. Pradeep Nayak, member of the organizing committee, shall escort them on stage. Our first adjudicator is Mr. K Nandakumar, senior advocate. Unfortunately, Mr. Sreevatsa could not be here with us today. We have Mr. Harish Narsappa, Senior Counsel, Member, Organizing Committee of the Bangalore ADR Week, stepping in as the second adjudicator on the Parliamentary. For the proposition, we have with us Mr. Mohammed Shameer, Partner, Trilegal, and along with him, Srimati Lakshmi Menon, Advocate. Opposing the motion today, we have with us Mr. Ashok G.V, Partner, Allied Law Practices, and Mr. Tejas S R, Partner, Dua Associates. A very warm welcome to all members on the dais. We thank you for gracing us with your presence today. The first adjudicator, Mr. K Nandakumar, is an alumnus of the National Law School of India University. He started his career as a corporate lawyer and thereafter began his tryst with litigation at the offices of Holla & Holla in 2004. Within a few years, Mr. Nandakumar was a partner at Ashira Law and thereafter set up his own law chambers in 2009. Mr. Nandakumar is widely acclaimed for his knowledge and expertise in commercial laws and arbitration, and is a highly sought-after lawyer, especially in high-value commercial disputes. He is also a member of several leading arbitral institutions across the world and is a fellow of the Chartered Institute of Arbitrators. As someone who has had the privilege of many a warm and generous conversations with him as a junior member of the bar, it is my honor and privilege to welcome you, sir, to the dais. Please welcome him with a huge round of applause. Our second adjudicator, Mr. Harish Narsappa, is also an alumnus of the National Law School of India University. He completed his BCL at Oxford, where he was a Radhakrishna scholar. He thereafter set up his own law firm, now Samvad Partner. He is also the founder of a non-profit, Daksh, which assists with public policy and access to justice rights. A senior counsel, Mr. Narsappa has appeared in several high-value commercial disputes, especially shareholder disputes. We are glad to have you, sir. Please welcome him. I now hand over the stage to Pratik Joshi to introduce the speakers.
Thank you, Harsh. Good morning to one and all. I have the privilege of introducing the speakers for the day. For the proposition, today we have with us Mr. Mohammed Shameer and Ms. Lakshmi Menon. Mr. Shameer is a partner at Trilegal and heads the disputes practice at Bangalore. He has extensive experience in dispute resolution, particularly in commercial litigation, arbitration, real estate litigation, labor and employment disputes, etc. Please join me in giving a warm welcome to him. Ms. Menon is an independent legal practitioner with over 10 years of experience and represents a range of clients. She's a trained arbitrator at the Center for Online Dispute Resolution, has completed a FICCI Master's Trainers Program on Insolvency Law in India. In July 2021, Lakshmi was offered the Emerging Women's Leader Award by the Bangalore Chamber of Commerce and Industry. A warm welcome to you, Lakshmi. Opposing the motion today are two seasoned litigators, Mr. Tejas S R and Mr. Ashok G.V. Mr. Tejas is a partner at Dua Associates and is an experienced dispute resolution lawyer with a focus on corporate and commercial dispute resolution. He is also actively involved in developing pre-dispute strategy and dispute resolution strategy advisory work. A warm welcome to you, Mr. Tejas. Ashok is a partner at Allied Law Practices and represents clients corporate and commercial disputes. He regularly lectures on posh matters and conducts training on similar issues for large corporates. A very warm welcome to you, Mr. Ashok. Now we have Mrinal explaining the topic for the day.
Welcome back, everyone. The topic for the debate before you today is whether the arbitration jurisprudence in India is being influenced excessively by the principles of the Code of Civil Procedure. I think the requirement for this debate was best captured by one of our panelists yesterday, who said that up till a certain point in his career, he felt that the only difference between arbitration and a civil suit was that in one you argued while sitting down and in the other you argued while standing up. Unfortunately, that is the reality of the situation we face in many of the arbitrations we have conducted ourselves. The CPC is not strictly applicable to arbitration proceedings. The Evidence Act is not strictly applicable. Yet we find ourselves in situations where parties insist, and sometimes even the tribunal insists, that they be followed to a great degree. This has resulted in arbitrations being slower than we expect and longer than we expect. So, therefore, to start the debate, as I had promised you prior to breaking for the tea break, we would require audience participation. As a part of the debate, we would require the audience to first vote for and against the motion before the debate begins, and then pass on the onus to the debaters to convince you otherwise by the end of the debate. So, may I request those for the motion, that is, those who believe that the principles of CPC do heavily influence arbitration proceedings, to please raise their hands to start with. Wow, that's the majority. So I guess the task is clearly set out for the debaters. And those against the motion who believe that the principles do not excessively influence arbitration proceedings, to please raise their hands. Okay, so that's like, I think, a 80-20 task for the debaters. Best of luck to all the debate. I would now call upon Tamara to introduce the rules of the debate to you, and then for the debate to commence. Thank you.
Now that we know what each one has to do, you have a cumulative time of 14 minutes.
I think moving on. Now, as far as framing of issues is concerned, Order 14 of CPC says every material proposition that is asserted by one and denied by the other has to find its place as a material issue. Now, in arbitrations, going by our own experience, the simple issue that will be framed is whether the claimant proves that it is entitled to so-and-so amount claimed in so-and-so paragraph of the statement of claim. Is that not an issue as good as any other? Similarly, now if we move to now examination of witnesses, while Order 18 has a full scheme on how witnesses have to be examined, recalled, summoned, etc., isn't a simple logical scheme which most arbitrators tend to propound, having especially regard to the nature of the dispute, to say this is how the witnesses will be examined and cross-examined, isn't that a workable solution? So if you now look at the life cycle of an arbitration, starting from filing of pleadings all the way till conclusion of an award, if all of us as practitioners are able to make do without the CPC, can an argument really be made that it is desirable to have CPC shape arbitration jurisprudence? The third, now, despite all of this, if my learned friends on the other side were to argue that it is desirable to allow CPC to shape arbitration jurisprudence, what is the obvious result that we will look at? How many adjournment applications will you land up opposing in arbitration proceedings? How much of delay will you see in an arbitration proceeding simply because at every step of the way CPC tends to dictate how an arbitration proceeding is to proceed and conclude? Now, if you were to really take the CPC and apply it to arbitrations, I think the outcome that all of us as practitioners will have is arbitrations will be infected by the same disease that our civil suits today are infected, which is basically the delays. So therefore, I think even on a practical note, there is no argument to be made that CPC should be allowed to influence arbitration proceedings. Now, just to offer an alternative. Now, let us test my proposition to the extreme, which is if you today legislate and say CPCs are absolutely not to apply to arbitrations, what is the kind of world that we will look at? I'll start with ad hoc arbitrations first. As I said right at the beginning, dehorse the provisions of the CPC starting from filing of pleadings all the way till an award is pronounced. Aren't arbitrators able to devise ad hoc procedures that are well catered and well suited to the needs of an arbitration? Similarly, now, in any case, if the arbitrator were to make a procedural determination in the course of an arbitration, and however displeasing I may find that procedural determination to be to my own personal liking, does that really make a convincing ground for challenge under Section 34 of Arbitration Conciliation Act? I think I can say with sufficient force that if I were to argue such a nuanced procedural submission before a Section 34 court, it will be thrown out right at the outset. So, we can see that ad hoc arbitrations are workable without the CPC. Now, institutional arbitrations that way have taken 2 steps ahead. They have their own institutional rules which govern arbitral proceedings, and we have seen in practice that those institutional rules are a viable substitute for CPC as we know and see it. So therefore, I think to just sum up right at the end, I would just say this. Going by our own personal experience, which I think by the show of hands that we saw right at the beginning of the debate, we have done quite well without CPC in arbitrations, so therefore I don't think we need CPC in arbitrations.
Respected judges, fellow members of the bar, my learned colleagues and the adjudicators, thank you for this opportunity to address a very pertinent topic, which is the influence of CPC on arbitration. I think at the outset, it was clear that the opinion poll was heavily weighted against us, with most people thinking that this is not desirable. But I think as members of the bar, accustomed to the culture of fundamental rights, we always know that the majority opinion is not always right. So I think let's keep an open mind on that front. So keeping that in mind, I think the first proposition that I wish to address, which was that there's no room for the CPC to influence arbitration jurisprudence. The fact of the matter is that the courts of this country have already disagreed with that proposition. Because if you look at the relief under Section 9 of the Arbitration and Conciliation Act, the principles under Order 39 or Order 38 has heavily shaped, and for good reason, the jurisprudence on the grant of ad interim reliefs under Section 9. So the argument that there is no scope for the CPC to enter into the domain of the Arbitration and Conciliation Act, I think I am not making that statement. The courts have already held it in the favor of the fact that CPC can shape up the jurisprudence under Arbitration and Conciliation Act. The second thing that I wish to address is this common misconception that everything that ails the system in the civil courts is ultimately attributable to the Code of Civil Procedure. I think somewhere it takes away the responsibility of the lawyers themselves who have contributed to the ails of the system in terms of adjournments and innumerable applications and the rigidity of procedures. The CPC, on the other hand, represents a very curious balance between two things which I'll address, and the first of which is the fact that ultimately for arbitrations to become lucrative and a preferred option, it must also be predictable. And an arbitration procedure which is completely left in the open without any influence of a tempering force such as the CPC also runs the risk of becoming inconsistent, unpredictable, and therefore not desirable, especially for the purposes of attracting investments. Let's look at this proposition for a second. What do we ultimately need from a good adjudication procedure? We need fairness, we need consistency, and we need predictability. And let's look at a world where this is not defined by something like the CPC. In one of my recent arbitrations where I was representing a Dutch client before the LCIA, governed by Dutch law, the Dutch civil code is something that we had to probe into, and curiously enough, unlike the textualism that English common law requires, where you're constantly interpreting the plain language of the provision of law, the Dutch courts can even ignore the law or can give a judgment completely contrary to the law if there is possibility of achieving justice. Now imagine if we were to read a flexibility of that nature into arbitral proceedings. Just the other day somebody mentioned how an NBFC related in-house arbitration resulted in 1,500 awards on a particular point of time within a very short frame, all in favor of the sponsor of the arbitration, which is the NBFC itself. Now, when we look at a situation of this nature, what we look for is how do we then temper down the discretion? We look at balancing of interests, equal treatment, good faith, proper procedure, so on and so forth, all of which is essentially already defined by Section 151 of the CPC. Now we have centuries of common law doctrines, equitable doctrines, that we have had the benefit of codifying into the Code of Civil Procedure of 1908, and yet the proposition being made by my learned opponent is that let us ignore the centuries of wisdom and say, let's go back to the Wild West. And I think that is precisely what will defeat the cause of arbitration in this country. The next point that I wish to bring about is the certain rigidity that is attributed to the CPC, which I once again heavily disagree with. If you look at the procedures under Order 39, Rule 1 and 2 and Section 151, 1908 is the year of the CPC, and in the year 2020 onwards, we were confronted with the problem of online piracy by sites that were repeatedly coming up despite injunction orders. And what did the Delhi High Court do? It read Section 151 and issued a dynamic plus injunction, which shows the CPC is capable of being agile, adaptable, and evolved with changing requirements of the times. Furthermore, when you had a problem of unknown people infringing on copyright and trademark, we evolved the doctrine of John Doe orders against unknown defendants, which is again an innovation that the CPC not only permitted but enabled and provided for with reference to Section 151 of the Code of Civil Procedure. Now, with all of this in place, I think the one point that I wish to finally summarize my points on is the moment we dwell into the topic of discretion and how do we exercise that discretion effectively, keeping in mind principles of flexibility and consistency. The fact that the Arbitration and Conciliation Act does not place a prohibition against the principle of CPC being incorporated is very telling and symptomatic of the fact that whenever arbitrators find themselves in the lurch and unable to understand or address a new situation, they have the benefit of falling back onto something that is well defined, the jurisprudence on which is shaped across several decades of court judgments and several centuries of common law doctrines. Last but not the least, I wish to state this, that if Section 18 of the Arbitration and Conciliation Act has to be given effect to, parity of parties, equitable treatment, fairness in the procedures, the one thing that we have to realize is that the Code of Civil Procedure has taken what is a very complicated system of equity, so sensitive and so delicate, and reduced it into a process, and best exemplified by prima facie case, balance of convenience, irreparable harm and injury. And the possibility that somebody is able to, as lawyer, come forward and say that let us ignore all of it because it's not relevant, it's not needed, to my mind, I think does disservice to the proud traditions of the judiciary in this country. With that, I conclude. Thank you.
Good afternoon, all dignitaries on and off the dais. This is Lakshmi for the proposition. First disclosure, both the learned adjudicators should have given you a conflict check before. I think I'll take that for granted, everybody is aware. I must start with where my learned friend stopped. Learned friend on the opposition said that unfortunately we are giving CPC, which is rooted in fairness, equity, etc., a complete go-by. Now that's not what we are trying to do here for the opposition, sorry, for the proposition. May I also say that the life of the law, as Lord Denning put it, is logic. It's never A or B procedural code. If the learned arbitrator or a panel is guided by the senses of equity, fairness, justice, I don't think it is necessary to rely upon a code as such. Section 19 of the Arbitration and Conciliation Act is an example of that. It is the trust reposed by the legislature to leave it to the arbitrator to think about the weightage, the materiality, etc. of evidence, and anything in the form of pleadings that are presented to the arbitrator. If the consumer forum can do it through a summary procedure, why not arbitrations? If, again, the learned Supreme Court has already made it clear that the Arbitration and Conciliation Act is a complete code on its own, then everything that the opposition just said is demolished. Because my learned friend also mentioned that time and again, because there are interpretations placed on the Act that if something is not excluded, that means it has to be applicable, is already under scrutiny. ITI Limited, the judgment by a 3-judge bench of the Honorable Supreme Court, is now under scrutiny by Justice Deepak Mishra's 3-judge bench in Mahanagar Telephone, where the judges have laid emphasis on the fact that just because the legislature couches something in the negative and says that this is not excluded, doesn't mean that all provisions of the CPC which are not in conflict with the Arbitration Act have to necessarily be implied and read into the Act. Now, if I have to take concrete examples and bring to the focus of this learned audience what the overplay of CPC does to an arbitration. Again, I don't want to say this, but even fundamental rights can be demolished by democracy, and that's what we saw when the audience raised their hands in a poll. I think all of you are also speaking out of your own experiences. Let's start with a referral. When I file an application under Section 8 to a learned civil judge here, why do I have to support it with an affidavit? Why is it essential that we borrow the short form of an application, put full cost title, and then follow it by signatures of parties? What if I don't get it notarized? If my power to refer a matter to arbitration stems from the Arbitration Act, and the Act does not make it compulsory to verify all pleadings in a format that we are used to under trials, that cannot be the reason why an application has to be rejected, at least in our view. Similarly, at the stage of Section 9, when you ask for an interim order from a court just before the tribunal is constituted, we have a practice in our courts, and I say this with great respect, just completely unnecessary, where you file one application under 39 Rule 1 and 2 asking for an interim relief in an interim relief application. Then there is a main petition arguing on that interim relief. So by virtue of interpreting CPC into the Act, we have now created 2 layers of interim reliefs which are really not founded, and they don't have real foundation within the Act where we are praying for such a relief. Similarly, in an SLP, that arises out of a Section 11, borrowing or echoing the sentiments of the previous panel also. Where is the provision to file an SLP against an administrative order, I ask myself. If it is only on the appointment of an arbitrator by either the respected High Court or the Supreme Court, it should not be allowed. This is again a hang-up of the court system, read with your over-reliance on CPC-like provisions. Similarly, let us come to an appeal. In fact, there's a very interesting quote by a learned philosopher who said, the real trouble of a litigant starts when they have a decree in their hand to enforce. In an appeal, if I am now under Section 34, for instance, the same example that I took of ITI Limited, where the Honorable Court first took an interpretation saying that if there is a challenge that I make to the appointment of an arbitrator, now it should be treated an appeal can, because of this judgment, can be treated as though the provisions of CPC will apply. Now, the question before the Honorable Bench in that case was, can I file cross objections to an appeal that I file under the Arbitration Act? And interestingly, the court took a view saying, yes, you can, because appeal provisions from CPC can be applied. I think they got slightly confused because the 1940 Act, if we remember, under Section 47 said specifically that CPC applies insofar as appeals are concerned even under the Arbitration Act. But that has been consciously excluded by the legislature, something that the court completely missed, in my respectful opinion, which decision is now doubted in Mahanagar Telecom. Similarly, if you look at the principles governing a Section 37, a second appeal, again you have courts that say that you need to provide a substantive question of law before the court to adjudicate a second appeal within an Arbitration Act. Where is this coming from within the Arbitration Act, I ask myself. Therefore, at every point in time, because we are so used to being trial lawyers first and arbitrators or arbitral lawyers next, because of our training, because of a lack of a mindset change or a shift, it's habitual on our part to rely on CPC, where my learned friend also pointed out how international organizations or how institutional arbitrations have gone leaps and bounds ahead of us, simply because they have been able to distill what we have in the CPC into simpler forms of procedure, and they have come up with more innovative solutions. I'm not saying let's look to the West for all answers, but I'm also saying why can't we innovate in-house? If a secretariat, say in an ICC proceeding or a London or a SIAC arbitration, is able to take away the requirement of the arbitrator looking at each and every pleading, and the arbitrators are only left with the substantive work to do, I am sure and I'm certain that with sufficient training, we can do that with our very own system here in Kanija Bhavna or in any other form of ad hoc arbitration, where principles can be emulated. But I do not subscribe, and I don't think that we have time in that 1 year window that Section 29A says all arbitrations must be effectively concluded. That effectiveness does not necessarily have to be pinned into A or B civil procedure, especially the 1908 Act that my learned friends on the other side so heavily relied upon. With that, I think I'll leave it to my learned friend of the opposition to counter me on everything that I just said.
I think my friends for the proposition have justified the adage, if you can't convince a judge, confuse the judge. So let me break this down. Let's go back to the basics. Now here we're talking about what Shameer started with, saying that there's no basis in the Arbitration Conciliation Act for incorporating the CPC into the procedure. Now let's understand one thing. There is no other procedural law in India. It's just the CPC. What they are trying to rely upon is Section 19 of the Arbitration Conciliation Act, which gives parties autonomy to determine the procedure, or in the absence, the arbitrator to determine the procedure. Now, I don't think in the previous session, one of the counsel mentioned, Mr. Bharat mentioned, that arbitration clause or the arbitration agreement is a midnight clause. No party, when formulating or entering into or negotiating a contract, pays much attention to the arbitration agreement and only comes back to it once a dispute has been raised. So expecting parties to determine procedure prior to a dispute having been raised is extremely impractical. Nobody is going to do that. Let us come to a post-dispute stage. Now, is a party, after a dispute has arisen, going to sit across the table and negotiate the procedure to be followed by an arbitral tribunal to adjudicate their disputes? I don't think so. We come back to the alternative of the arbitrator determining the procedure. Now, while the Act does give leeway to the arbitrator to determine the procedure, and in most circumstances, arbitrators do determine their own procedure and are not strictly bound by the CPC, there are circumstances where the CPC, which in effect is more than a century old, which has 158 sections, 58 orders, multiple and jurisprudence precedents on multiple aspects. Thousands of judges have applied their brilliant legal acumen and set out procedures and interpreted those provisions. Now, are we saying that I do not want to look at any of that, even as guidance, even as some sort of way to interpret and understand how to proceed in a proceedings, and give a way, go by to all of that just because I don't want to be bound by a procedure? Now, the argument which has been placed by them is CPC leads to delays. Now, all of us have practiced before trial courts. All of us have practiced and led trials and conducted trials. Our experience has been, It is not the CPC which causes delays. It's the other participants, be it the lawyers, be it the judges, be it the infrastructure. Various other factors are the ones which contribute to the delays. We have all had wonderful experiences before the trial court where trial has been conducted super efficiently, and we've gotten judgments, we've gotten decrees, we've gotten judgments and decrees and executed. So it is not the CPC which leads to delays, but the other actors, other variables which are involved in the arbitration process which leads to the delays. So if the argument is being propounded that it is the CPC which leads to delays, I'm sorry, that's not the case. It's the various other factors like the arbitrators, the lawyers, the parties who are involved in arbitrations. Now, if assuming that the parties themselves formulate a procedure, or if the arbitrator comes up with a procedure, is that automatically going to end all delays? No, because an innovative counsel and a party is always going to come up with ways to delay proceedings. So that is not the end solution to end delays and make arbitrations more efficient. In fact, weaving the CPC into arbitrations will lead to more certainty, because there is a precedent, there is an application of mind which has gone into following a particular procedure, and hence will in effect lead to lesser challenges to arbitral awards, and thereby speeden up the entire process itself. In fact, if you look at the whole the Arbitration Conciliation Act itself, the CPC has been woven into it. You look at section 17, it specifically talks about execution of interim awards by means provided under the CPC. Look at section 27, which talks about witnesses. The provisions of the CPC have been woven into it expressly. Look at section 36 for enforcement, executable enforcement of awards. CPC's provisions have been specifically woven into it. So the argument that the CPC has nothing to do with the Arbitration Conciliation Act is flawed. CPC is integrally woven into the Arbitration Conciliation Act. Now, what would you do in the absence of CPC? Of course, there are institutional arbitrations where institutions provide for certain procedures to be followed on certain aspects. But these are also not exhaustive. Like our own Bangalore Arbitration Conciliation Center has procedures for discovery, inspection, and various other aspects. And where specific procedures have been laid down, there is no arbitrator who will go beyond that and say, I'm going to follow the CPC and not the institutional procedure. So CPC only acts as a stopgap arrangement to fill in and give assistance to both the arbitrator and the parties on how to proceed to ensure that there's a fair trial. And once you ensure there's a fair trial, the chances of it being set aside on the grounds of public policy, violation of fundamental policy of India, violation of principles of justice and morality, patently illegal, all of them automatically fall away. So ultimately, looking at it from a narrow perspective as Order 6, Order 7, I don't want to sign a verification is inconsequential, because ultimately, in the larger scheme of things, this would help cement arbitration as a preferred alternative dispute resolution mechanism, make it more certain, make it more expeditious, and which is the ultimate objective of the Arbitration Conciliation Act, to provide a more efficient and expeditious disposal to proceedings. In fact, even in the previous session, Justice Krishna Kumar mentioned that scuttling the process by litigants is one of the challenges faced by the judiciary. This is something which is within the mindset of the litigants and the parties and the advocates. And this is not something which can be attributed solely to the CPC. Let us assume for a minute a party uses the CPC to delay proceedings. Does the Arbitration Conciliation Act not have any remedy to it? Let's look at section 31A, costs. Arbitration Conciliation Act was specifically amended to provide the arbitrator with a mechanism to impose costs on parties for 1, frivolous counterclaims, 2, any conduct of theirs which would result in delays, even with respect to particular actions of the parties or steps taken by the parties during the course of the proceedings can be penalized by way of imposition of costs. Hence, the Arbitration Conciliation Act itself has sufficient measures to address the argument of delays, and this can be used by arbitrators as an effective mechanism to counter the allegation that procedural delays can be misused, procedural aspects can be misused by parties to lead to delays. Thank you.
I must say, I think it was a valiant effort by the other side, despite the prevailing sentiment in the House. But I think the first argument that was raised, which is, it's not the CPC to blame, but it's the practitioners to blame, is I think a classical argument that has been beaten to death. Now, to sort of overcome that argument, let me just present one example which I'm pretty sure is closer to all of your hearts. How many of your applications have been returned by judges to mention the correct provision of law and file it on the next date of hearing? So therefore, to sort of say that it's the practitioners that are causing delay and not the CPC itself that's causing delays, I think is to argue against, the troubles and problems that we ourselves as practitioners face day in and day out in our own practices. Now, second, I think the argument that was raised is that, very interesting though, which is CPC brings in a kind of flexibility into the arbitration process. Now, I don't think I agree at all that CPC brings in any kind of flexibility. If for anything, CPC brings in a kind of rigidity that you don't see in an arbitral process. To go back to an example that I quoted earlier, which is the CPC as a standard says parties are entitled to a period of 90 days for filing their written statement. Now, haven't we seen arbitrations where that 90 days period is not merited? That an arbitrator should have the discretion to say that this is a fairly simple dispute, so therefore, for filing of statement of defense, no more than 30 days time will be granted for the purpose of filing a counter or a statement of objections. So therefore, to sort of argue, to say that CPC would bring in a kind of flexibility into an arbitral process is to just overlook the substantive provisions of the CPC and argue in vacuum. Now, another third very interesting point that was raised was, a popular an opinion might be popular, but it may not be necessary that it is the right opinion. And also CPC is an embodiment of centuries of wisdom. Now, I think I would answer that argument by just asking a question. Where has that centuries of wisdom led us to today? Are we standing, as a result of the centuries of wisdom, are we today standing at a place as far as our civil suits are concerned? Are we standing in a place where we like to be? I think the answer is a no. Two other arguments that were raised is CPC is interwoven into the Arbitration Act and CPC leads to lesser challenges. Now, if you see section 34, the grounds of challenge, and this is something that I referred to at the beginning of the debate as well. Where is there a ground for challenge interwoven under section 34 of the Arbitration and Conciliation Act for a mere procedural irregularity? It is not a ground that can be raised as a ground for challenge under section 34. So therefore, to say that CPC would reduce the possibility of a challenge, I think is basically arguing against the text of section 34 of the Arbitration Conciliation Act. Now, lastly, I think to sort of say Arbitration Act can be used to counter the delay, or rather, there are provisions within the Arbitration and Conciliation Act which can be used to counter the delay that application of provisions of CPC will cause. Is like saying, let me first infect the patient by a virus and then give him a paracetamol to cure that virus. So therefore, I don't think in today's day and age, especially as practitioners, when we see the practice of arbitration, there is any space really to say that substantively CPC should be allowed to influence the process of arbitrations or arbitration jurisprudence.
I think my opponent made a statement, fundamental rights can be demolished by the audience, which is a very appropriate metaphor to the opinion poll at the beginning of the debate. There was a demolition of the fundamental rights. So I think a lot has been said about how the CPC throughout, though embodying centuries of wisdom, has taken us nowhere. But we also have to remember that Bangalore or Karnataka did not have courts issuing written judgments during the time before the British. Our jurisprudence has evolved in a very quick succession compared to what it was in England, primarily because the provisions of law such as the CPC brought in a degree of a modicum of seriousness, a modicum of finality, and a modicum of fairness and ways to temper down the inherent flaws of the system such as bias and lack of predictability. To say that centuries of wisdom has led us nowhere, I think we haven't even begun to experiment or determine how far along it's come, because the India as a country is very new. And if you look at the leapfrogs we have made as to what courts in India were before the CPC came in or before these laws entered into the picture and how far we have come along, CPC represents a leapfrog. It's not incremental changes, it's a leapfrog. Second, I think one of the points made was that logic is central, so procedure can be flexible, and reference was made to summary procedure. Let's look at what happened with summary procedure. NCLT decided to admit a winding up petition against Flipkart. That's what the sum total of summary procedures can do. A perfectly profitable company which is just on the verge of receiving a major FDI investment was subjected to a winding up action. Summary procedures, I don't think always work, especially in the kind of nuanced cases that arbitrations deal with. Last but not the least, I think much has been said about the provision of CPC dealing with the outer limit of 90 days or 120 days in terms of filing the written statement. But what is not understood is that the 90 days or 120 days is the outer limit. It is not the minimum time period given to any defendant. And fact of the matter is, ever since the Commercial Courts Act came in and amended the CPC, a lot of the traditional ails of the CPC, so to say, which had less to do with the CPC itself and more to do with how it was being administered, has been addressed, and those amendments can very well be beneficial in an arbitration proceeding to address the very kind of delays that was being spoken about, or the lack of a plan for case management hearings, because the CPC now contemplates case management hearing in commercial disputes to ensure that trial procedures are fixed. So to say that the CPC somehow is singularly to blame for everything that ails the system, I think does a disservice to the ground realities, which is the fact that there is a divergence in the application of the CPC across different court halls. Even our experience from one court hall to court hall with CPC itself never remains the same. I think it finally comes down to one point that I want to make. The Arbitration and Conciliation Act does not mandate that the CPC influences the way arbitrations are conducted. But what it does, it gives the option to the arbitrators, whenever they're confronted with questions for which there are no ready answers, to fall back onto something that has been shaped up so well across the centuries that it acts as a ready reckoner. Again, going back to the Dutch Civil Code, which leaves so much in the air. Things like fairness and equity, which is so abstract, which is so hard to define, CPC has the benefit of reducing it to a method. And that kind of progress that we have made in terms of giving a code that is as well thought out, which reduces something so philosophical and abstract to something so certain, something so methodical and almost a science. I don't think it is right on our part to say that let us assume that that is the source of all the ailments and ignore it, because the alternative would be to go back to nothing. And I don't think that's that's something that we desire. Thank you.
Thank you to all our debaters. I know Ashok and Tejas had a slightly more uphill task than Lakshmi and Shameer. So time to get back to the vote again and see whether Ashok and Tejas have succeeded in changing your minds. So those for the proposition may again please raise their hands. Whoa, there does seem to be a change in mind. And those against the proposition also please. Okay, so I don't think either party has strictly won, but it's close to a tie right now. So we'll leave it up to our adjudicators.
The audience would decide for us, but clearly now we have a job to do. A couple of quick remarks on the debate itself before we get to the decision, as it were. The point that was made about the Commercial Courts Act and the amendment was a very interesting one. I was hoping it would have come up a little earlier. Obviously, does that lead the question, does it mean that the CPC wasn't being effective, that there was a need for a new mechanism? I think somewhere, as far as the speakers on the opposition side are concerned, maybe the scope of how they defined the topic was more to say, does the CPC still have any use in arbitration, rather than whether or not it influences arbitration. I think the way the proposition reads, it is if CPC still influences arbitration and how arbitrations are conducted. There perhaps there is a slight redefinition that they've chosen to do, which is whether or not CPC still has any use or validity when it comes to arbitration. The speakers for the proposition perhaps took things a bit for granted and thought the audience was with them. But this is the danger of going with the audience poll. And you've seen even on KBC that sometimes the audience is wrong. So clearly, Shameer and Lakshmi, well done. It was very interesting to hear both of you, and Ashok and Tejas as well. Harish, couple of remarks if you would like.
So the first arbitration clause that I ever saw was when three very good friends had decided to start a business together. And their spouses, incidentally the three very good friends were all men, their spouses were also very good friends. So in that, when they drew up the partnership deed, they included an arbitration clause, and the tribunal was the three wives. Now, I wonder where CPC comes in there. And I got involved because a dispute actually arose. And thankfully, the three wives said, enough of this nonsense. I think you guys are good friends. Wind up the business and be good friends together. So it was a very good decision. So I think, hats off to Ashok and Tejas because they brought about 40% of the audience back. And I think Lakshmi tried to influence the adjudicators by claiming her special relationship. But see, is there a need, I think behind the debate, I think is there a need really for lawyers to mention provisions of the CPC in every application they file before an arbitrator? It's not necessary. And the Arbitration Act says it in so many words. It says CPC is not applicable to the proceedings before the arbitrator. Are we being excessively influenced by the CPC? The answer again is, if you ask practitioners of arbitration, the answer is yes. Whether it is because of philosophy or provisions, that's a separate issue altogether. If you're saying natural justice philosophy should be there in arbitration, I don't think anybody disagrees with that. But is it being excessively influenced by CPC? I think that is the proposition. So I think it suited you to, take it to philosophy to convince half the people. So well done. So thank you very much.
One other remark I just wanted to make was a reference was made to sections 18 and 19 of the Arbitration Act. But you must also bear in mind, and something that I think Ashok mentioned, section 28 and how much discretion that an arbitrator is in fact allowed. Because if you look at 28, sorry, it does say that unless the parties have conferred equity to the arbitrator as part of what the arbitrator can decide, the arbitrator cannot assume equity. That's the effect of what that Latin phrase is in that provision. Therefore, it's a bit dangerous to say that CPC has discretion and therefore we could incorporate that into it. But that being said, I mean, excellent points made on both sides. And maybe give us a minute, we'll if nothing else, toss a coin and decide who the winner is. In good CPC style. Given that it's a ADR conference, we'll play it safe and go with the proposition and the audience. And for the record, I did give in a Section 12, Schedule 5 disclosure before the hearing commenced to the organizers. Thank you so much. Thank you to both sets of speakers. Very well done. Congratulations.
Thank you very much to our adjudicators and to the debaters. I'm sure a lot of points came out which usually we do not think of, especially for the team against the proposition. I know it was a difficult task and that was an innovative debate. We would like to thank all the debaters and adjudicators on the stage. May I call upon Mr. T.G. Ravi and Mr. Dinesh Hegde to come onto the stage and kindly felicitate the adjudicators. Mr. K Nandakumar, Senior Advocate. Thank you so much, sir, for your time today. Sirs, if you could please stay back, Mr. Ravi and Mr. Hegde, for Mr. Harish Narsappa. The conflict has been disclosed, Harish, so it's fine. May we request Mr. T.G. Ravi and Mr. Hegde to also express a token of our gratitude to Ashok. And to Tejas as well, please. And to the other team also, Mr. Ravi and Mr. Hegde. On this side of the dais, Shameer and Lakshmi. Thank you so much, sirs. Thank you everyone on the stage for your invigorating debate and thoughts shared today. We now are moving towards the valedictory session. To start that off, Mr. Harish Narsappa will address a short report of the event. So I call upon Mr. Narsappa.
Good afternoon, everyone. Honorable Justice Mudgal, I was debating how to address her, but I think the most appropriate address for Justice Mudgal, because of the last 3 days, is she's the captain of the Bangalore ADR week. So with the permission of the captain, I'm going to take about 10 minutes and give a short report of the event. While looking at the details, we should also not forget the significance of this event. It's probably the first time that such a cooperation has taken place between the bar and the bench and the arbitration center and the Judicial Academy to hold an interactive conference of this nature to bring all the legal community together, because we have different roles, but we're all striving towards the same goal. So that's why this event is very significant, and it came out, and the message came out in the inaugural session when both Justice Nagaratna and Justice Arvind Kumar pointed out that we need more of these interactions, and I think Justice Nagaratna told us on the stage itself that some of the sessions missed out this year should happen next year. So she's already set a goal for the next year. We do hope that this interaction will continue, because it's necessary to evolve the ecosystem. And that's a topic that came out in various panel discussions. Right from the first panel when Justice Ravindran led the discussion on improving professionalism. And the message that came out was, it is the role of both lawyers and arbitrators and the judiciary to improve the level of professionalism that already exists but needs to get better in the arbitration ecosystem and in the ADR ecosystem. Now, if we go through the various panels, we were lucky to have participation from both the bench, retired judges and sitting judges of the High Court, and very senior practitioners. And we have had fantastic response from the audience, and many people have told us that the level of nuanced interaction was very high. And we have had a couple of participants who have come from different cities, Mumbai, Delhi, and who also said this is probably the first time where such a conference is focused on discussing the issues and not merely to promote one institution or the other. So it is really a coming together of the community to promote ADR as a mechanism, and that's something we should be proud of and take forward. Now, in terms of action plans, and Justice Mudgal will talk about this more in her remarks, there are many messages that we have got. One, at a sort of concrete level, and Justice Poonacha addressed this yesterday, in terms of thinking about strengthening the arbitration center, which is a co-host of this conference. The need to continue the training sessions that happened on Saturday were only for lawyers below 10 years, and I was actually cornered by a few practitioners and said, why did you limit it to below 10 years? There were some gate crashers, but they have stayed throughout, and they said they really enjoyed it, and they wanted this to become a much wider continuing legal education process as such. So I think that's a message for all of us, and both Justice Anu Shivraman and Justice Mudgal have told us that this is something we should think on as to how to continue this and take this forward. In terms of the ecosystem, I think there were many suggestions, very hard to process in just a day and a half and come out with concrete proposals, which is why instead of passing resolutions, we thought we will identify action plans. But the 3 or 4 broad topics is continuous interaction, which I've already mentioned, training for arbitrators and arbitration lawyers, as Justice Ravindran pointed out in his session, and Justice Bopanna also mentioned. It's something that needs to happen regularly. The creating some sort of forms for the arbitration community, both in terms of pleadings, in terms of orders, some sort of standardization. And this needs to happen at a community level, not at an institutional level. Otherwise, we may have a debate in about 5-10 years as to whether the procedural forms are taking over arbitration. So I think we need to keep some sort of flexibility that ADR systems enjoy, but also create some assistance for the community. Then I think we had one session on mediation, 2 sessions on mediation, because even the session Justice Bopanna chaired addressed a lot of issues on mediation, and then there was a session that was chaired by Justice Sunil Dutt Yadav yesterday on mediation, and then there was a session on technology, which was interesting when Justice Suraj Govindraj, we didn't know his technical side to his legal practice and to his acumen, and he simplified a lot of the technology issues that we can, as lawyers, we can adopt. And that, I think, again came out this morning's session, when infrastructure need not be just physical infrastructure, but how can we leverage technology to develop the institutional arbitration. And I think I have covered most of the topics. I only want to say that the participation level of both by the audience on the audience on the during the training sessions and during the business sessions was very involved, and we apologize that we could not accommodate all the questions in all the sessions, because as most of these conferences go, if one session gets delayed, then it sort of takes over the rest of the afternoon sessions. But I think today we are running on time. We're actually ahead of time, I noticed. So I think that gives us more room for Justice Mudgal to identify the action plans. And I will stop there because I don't want to repeat things, because it's only been 1.5. To conclude, I will say, I know we are calling it the Bangalore ADR week, and it was only a weekend really, finally, but that is the goal, to have a full week. And in fact, we had drawn up a full week schedule, but for various reasons, time constraints and other things, it was a weekend. So thank you very much for being patient and listening to a rerun of the events of the last day and a half. I now invite Justice Mudgal to please come on stage for concluding remarks.
My esteemed sister and brother judges, esteemed dignitaries, luminaries assembled here, arbitrators, advocates, academicians, judges, ladies and gentlemen. First I say Happy Krishna Janmashtami to all of you, which nicely coincides with the culmination of this event. It was said it was made as ADR week, but we completed it within 3 days. But 1 week program was packed in 3 days program. So there were parallel sessions. Some of us could not attend both parallel sessions, so we attended one alternate. This will be, web hosted or some digitally it will be made available to all. It's a great matter of great pride and responsibility to draw curtains to an event of this magnitude and importance. Minds with far more legal acumen in this area have graced this dais and shared their insights on the action to be taken in order to turn Bangalore and Karnataka itself into a global hub for commercial institutional arbitration. I must confess that personally, I am also benefited by this program. The potential is limitless. Bangalore is one of the richest cities in India by GDP per capita, at the tag of, I am given to understand, of Silicon Valley of India, along with the presence of startups, PSUs, etc., make for an exciting business environment. The hope of us as organizers is that this potential is transformed into value for the city, the state, and the country at large. This event will only be a success if tangible steps are taken to achieve its objectives. To conclude, I'd like to address some key areas of reform, both systematic and individual, to help turn this event into a true success. First one is, a need has arisen for curbs to be placed on the misuse of Section 34 and 37 of the Arbitration and Conciliation Act 1996. The fact that 2 levels of adjudication follow from the award of a tribunal renders the speed and efficiency of the arbitration moot and must therefore be addressed systematically. This was a concern shown by the participants and the speakers also. It's my hope that through consensus and deliberations within the fraternity, a solution may be found for the same. Second one is, an advocate serves the cause of justice and his client, and an arbitrator serves the cause of justice and efficiency. Efforts must be made by all stakeholders to remember this. As many of the wise luminaries during the sessions and dignitaries have pointed out, inflated claims and counterclaims, lengthy pleadings, and prolonged proceedings are derogatory not only to the interests of clients or justice, but destructive of the cause of arbitration itself. We are part of a system that is only gradually accepting the feasibility of this system. All of the above actions I mentioned leave distaste in the minds of justice seekers, because many of them expressed here today on dais in this debate that they are not able to get relief despite many years. And our goal of creating a global hub for arbitration shall further be delayed if there is delay by such lack of foresight. Third one is, there is a dire need to inculcate awareness, professionalism, and proficiency among the legal fraternity towards this. This involves not just an attempt to acclimatize and accept the advent of arbitration, but also to cultivate both technical sense and professionalism to handle the matters. Further, there must also be keenness with the legal fraternity to engage with the practice and recognize its benefits for the clients, the courts, and the advocates themselves. Fourth one is, fourthly and lastly, attempts must be made to integrate other forms of ADR such as conciliation and mediation into the process of arbitration to ensure the best possible outcome for all stakeholders and decrease the likelihood of zero-sum games. Efforts must also be made to harness the interest of technology-friendly environment of Bangalore to make it a pioneer in India towards the adoption of online dispute resolutions as well. With these few observations, I'll not take much of your time. We know many of us, you probably stayed back because of the debates. On behalf of the organizers, I'd like to thank each and every one of the participants for making this event such a grand success through your knowledge, experience, and inputs of the wisdom. I would also like to thank all involved in organizing this program who have put in their heart and soul and left no stone unturned in realizing the dream of this arbitration week effectively and creating such a professional and engaging ambience for the exchange of ideas. True, problems do exist in making Bangalore an international institutional arbitration hub. Since I started with a story, I am tempted to conclude with another story. Do you all remember the story we heard as children about the flock of pigeons trapped in a hunter's net? Each bird struggled alone. Probably all of you may be knowing the pigeons were entrapped in the net of a hunter. Each bird singly struggled but unable to break free. On the advice of one wise old pigeon, so many who spoke here, they all flapped their wings collectively, traveled to their mouse friend who cut the net with his teeth, and all were freed. Likewise, I am sure our collective efforts towards this aspiration of making Bangalore a global institutional arbitration hub will bear the fruit with consistent efforts and change. I wish you all very best. I conclude with the wisdom of our ancestors. Ano bhadra krutvo yantu vishwatah means let the noble thoughts come to me from all the directions. Thank you once again. Jai Hind, Jai Karnataka.
Thank you to Justice Mudgal for her support for this entire event from the very beginning. I now call upon Mr. T.G. Ravi, Secretary of the Advocates Association, to address the gathering. As you're all aware, this has been a true collaboration between the bar and bench, and the Advocates Association has played a crucial role in conceptualizing and supporting this event.
ಎಲ್ರಿಗೂ ನಮಸ್ಕಾರ. ಕೃಷ್ಣ ಜನ್ಮಿಯ ಎಲ್ರಿಗೂ ಶುಭಾಶಯಗಳು ಕೋರ್ತಾ, ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮೂರ್ತಿಗಳಾದಂತಹ ಮುದಗಲ್ ಮೇಡಮ್ ಅವರಿದ್ದಾರೆ, ಅವ್ರಿಗೂ ಹೊಂದಿಸ್ತಾ, ಪುಣಚೆ ಸಾಹೇಬರು, ಉಮಾ ಮೇಡಮ್ ಅವರು, ಹಿರಿಯ ವಕೀಲರುಗಳು ಮತ್ತು ಕಾಲೇಜಿನ ವಿದ್ಯಾರ್ಥಿಗಳು ಸಹಿತ ಇದ್ದಾರೆ. ಈ ಆರ್ಬಿಟ್ರೇಷನ್ನು ಯಾವಾಗಲೂ ನಾವು ಮಾಡುವಂಥ ಸಂದರ್ಭದಲ್ಲಿ, ನಾವು ಬಂದ ಸಂದರ್ಭದಲ್ಲಿ ಹೋಟ್ಲುಗಳಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ರು. ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಎಲ್ಲ ಹೋಗಿ ಒಂದು ಆರ್ಬಿಟ್ರೇಷನ್ ಮಾಡಬೇಕಂತಂದ್ರೆ ಒಂದು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ತಗೊಂಡಾದಾಗ, ಅದು ತದನಂತರ ಒಂದು ಆರ್ಬಿಟ್ರೇಷನ್ ಸೆಂಟರ್ ಅಂತಾನೆ ಮಾಡಿದ್ರು ಕನೋಜ ಭವನಲ್ಲಿ. ಈಗ ಹಿರಿಯ ವಕೀಲರುಗಳು ಮತ್ತು ಒಂದು ನ್ಯಾಯಾಂಗ ಇಲಾಖೆದಲ್ಲಿ ಒಂದು ಸೃಷ್ಟಿ ಮಾಡಿದಾಗ ಆಯಿತು. ಈಗ ನಾವು ಕೇಳೋದೇನಂತಂದರೆ, ಮುದಗಲ್ ಮೇಡಮ್ ಅವರು ಇದ್ದಾರೆ, ನಮಗೆಲ್ಲಾದರೂ ವಕೀಲರ ಸಂಘ ಮತ್ತು ನ್ಯಾಯಾಂಗ ಇಲಾಖೆ ಮತ್ತು ಹಿರಿಯ ವಕೀಲರುಗಳು ಎಲ್ಲ ಸೇರಿ ಒಂದು ಜಾಗ ಎಲ್ಲಾದರೂ ಕೊಡಿಸಿದ್ರೆ ಬಟ್ ಭಾಳಷ್ಟು ಅಚ್ಚುಕಟ್ಟಾಗಿ ಮಾಡ್ಬೋದು ಅಂತ ಹೇಳಿ ನಾನು ಇಚ್ಛೆ ಪಡ್ತೀನಿ ವಕೀಲರ ಸಂಘದ ವತಿಯಿಂದ. ಈಗ ಈ ಹಾಲ್ ನೋಡಿದ ತಕ್ಷಣ ನಮಗೆ ಖುಷಿ ಆಗ್ತಾ ಐತೆ, ಈ ಥರ ಒಂದು ಹಾಲ್ ನ್ಯಾಯಾಂಗ ಇಲಾಖೆಯಲ್ಲಿ ಇದೆ ಅಂತ. ಈಗ ನಮ್ಮ ಬೆಂಗಳೂರು ವಕೀಲರ ಸಂಘದಲ್ಲೂ ಸಹಿತ 1,000 ಜನ ಕೂತ್ಕೊಳ್ಳೋಂಥ ಆಸನ ಇದೆ. ಮೇಲೆ 7ನೇ ಫ್ಲೋರ್ಗೆ ಯಾರೂ ಬರೋದಿಲ್ಲ. ಇದು ಎಲ್ಲಾದ್ರೂ ನಮ್ಮ ಬೆಂಗಳೂರು ಆಜುಬಾಜು ಅಲ್ಲಿ ಒಂದು 50 ಎಕರೆಯನ್ನು ಕೊಡಿಸಿದ್ರೆ ಒಂದು ಅಚ್ಚುಕಟ್ಟಾಗಿ ಗೌರ್ಮೆಂಟ್ ಲೆವೆಲಲ್ಲಿ ಕೂಡ ಒಂದು ಆರ್ಬಿಟ್ರೇಷನ್ ಸೆಂಟರು ಮತ್ತು ಇನ್ನು ಭಾಳಷ್ಟು ಅನುಕೂಲ ಹಾಗಾಗಿ ಈ ಕಾಲೇಜಿನ ವಿದ್ಯಾರ್ಥಿಗಳು ಕೂಡ ಸಹಿತ ಇದ್ಕೊಂಡು ನಾವು ಅಡ್ವೊಕೇಟ್ ಅಕಾಡೆಮಿಯಲ್ಲಿ ಒಂದು ಟೀಚಿಂಗ್ ಅಂತ ಕೊಡಿಸ್ತೀವಿ. ಜುಡಿಷಿಯರಿ ಎಕ್ಸಾಮ್ಗೆ ಹೋಗುವಂಥ ಸಂದರ್ಭಗಳಲ್ಲಿ ಅಂತ ಇದಕ್ಕೆಲ್ಲ ಬೆಂಗಳೂರು ವಕೀಲರ ಸಂಘಕ್ಕೂ ಮತ್ತು ಜುಡಿಷಿಯರಿಗೆ ಒಂದು ಒಳ್ಳೆ ಒಂದು ಜಾಗ ಕೊಟ್ಟರೆ ಭಾಳ ಒಳ್ಳೇದು ಅಂತ ಹೇಳ್ತಾ, ಈ ಒಂದು 3 ದಿವಸ ಮಾಡಿದಂಥ ಸೆಷನ್ಗಳಿಗೆ, ಆ ಸೆಷನ್ನಲ್ಲಿ ನಡೆದಂಥ ಎಲ್ಲ ಇಂಟ್ರಾಕ್ಷನ್ ಇದಕ್ಕೆ ನಾನು ಹೊಂದಿಸ್ತಾ ನಾನು ಭಾಷಣ ಮುಗಿಸ್ತೀನಿ. ಜೈ ಹಿಂದ್, ಜೈ ಕರ್ನಾಟಕ.
Thank you, sir. Thank you, sir, for your kind words. Before moving on to the vote of thanks, we would like to thank the Board of Governors of the Arbitration Center, the Karnataka Judicial Academy, and everyone involved in organizing the event. As Harish rightly said, Justice Mudgal was the captain of this team. Therefore, we would invite Justice Mudgal onto stage to accept a small token of our gratitude. May I also request Justice M.G. Uma, who has been here for each day of the event and has attended all possible sessions, to also join us and accept a token of our gratitude. May I also invite Justice Punacha, who has attended a number of meetings with us and has been guiding us on a day-to-day basis for the event. Justice Nawaz is not here, but his involvement and guidance was also crucial for this event, so we would like to thank him. I now call upon Mr. Sriranga to address the closing remarks, and which will be followed by lunch. So kindly hold on for about 10 more minutes. Thank you.
Before we thank everybody and close the proceedings, I would like to call Mr. T.G. Ravi onto the stage. Request Mr. Harish to felicitate him with We have now come to the end of 3 days deliberations that we have held. We have had 7 sessions and 4 training sessions, small talks, debates, etc., exchange of various thoughts amongst all the participants. And I think there is consensus that this has been a great success. And first and foremost, we would like to thank the Patron in Chief, the Honorable Chief Justice of Karnataka, who has given his support at every stage for holding this event. Thank you very much, sir. Justice Anu Shivaraman, who is the President of Karnataka Judicial Academy, has also given us this venue, I think, which is also kind of novel that such a event is being held in Judicial Academy. We thank her profusely for her participation in various aspects and also providing us the venue. As Harish said, our captain, Justice Mudgal, has been hands-on and has participated not only in various meetings. We've made her skip lunch on many days because we have troubled her between 1:30 and 2:30, no end. And she has shown immense patience in dealing with all of us. And she has participated in most of the deliberations that we have held. In fact, she was the first one to arrive on the first day of the training to ensure that everything was in place, and even monitoring the dress code of participants who came in. To such an extent, she's monitored everything that has happened. We thank her profusely for her cooperation and participation. The Board of Governors of Justice Mohammed Nawaz, Justice Indresh, Justice M.G. Uma, Justice C.M. Punacha, they have all been present here, not only participated but given us valuable guidance at every stage. We thank all members of the Board of Governors for being of such support. The Director of KJA, Mr. Marathe, Mr. Alwa, who is the Additional Director, Mr. Sarfaraz Hussain, the Administrative Officer, Srimati Amrita, Assistant Director of KJA, Mr. Shambulingaya, who is the Principal of the Training Institute. They have all been of great support at every stage and making this event a grand success. We thank all of them from the bottom of our heart. Similarly, the other organization which has given us great support is the Arbitration Center. We thank Mr. Dinesh Hegde, the director of the center, Mr. Vignesh, who's been of great support, but unfortunately because of certain circumstances, he could not be part of the main event. Mr. Alok, Deputy Director of the Arbitration Center, they've been of great support to us at every stage. We thank all of them. The staff of Arbitration Center and the KJA have all taken this up as their own event, and they have given us great support for holding this event. We profusely thank the entire staff of Arbitration Center and Judicial Academy for being such great support. We also thank the Principal District and Sessions Judge Muralidhar Pai, and also all unit heads and judicial officers, and also stenographers of KGA for being of great assistance in all our endeavors and bringing various aspects like preparation, etc. We thank all of them for their assistance. I also thank all members of the organizing committee, Manisha Kongovi, Tamara Sequera, Pinaz Mehta, Mr. Prashant VG, Pradeep Naik, Mr. Menon, and Lakshmi Menon for ensuring that the present event is a grand success. We also thank all the panelists who have participated in all the sessions and deliberations, and also participants, trainers in the training sessions. In fact, in the training session, they ensured that even books are provided on arbitration. We are grateful to all the trainers who held 4 sessions on the very first day, and the response is that it was very useful. We are thankful to all the panelists and the trainers. I also thank a large body of advocate volunteers without whom we could not have conducted this event at all. There were various groups created working on each aspect of this, and meticulously which has been attended to and which has ensured that the event is a success. I thank all of them, the entire body of advocate volunteers. It may not be possible to name all of them, but I thank all of them for their assistance. I thank the students of Christ Law College. They call themselves as Vimarsh, who have assisted us in videographing, live streaming, and recording all the events. We thank all of them. In spite of they having their examinations, they have participated. A special thanks to Arjun Jaikumar, who has assisted us in creating this logo for the event, and also was assisted us in developing the website, and also developing the invite and various aspects, and he's been of great help. We thank him for his assistance. Then the event manager, Mr. Sushil, and his team of 3S events have created the backdrop and assisted us in every aspect of conducting this event. We profusely thank him for making this event a grand success. Thank you very much. There will be a short video that would be played now. There's another short video for day 3. After that, we can proceed for lunch.